Okay, my court case was Board of Education versus Earls.
Stop shaking.
So the school board of Tecumseh, Oklahoma required their students to do a mandatory drug test if they participated in any extracurricular activities, whether it was competitive or not. So like people on the debate team had to do it too. So 2 students named Lindsay Earls and Daniel James challenged the school board, and they claimed that the drug test violated the 4th Amendment of the Constitution. Their policy at the school was that all middle and high school students were required to consent to urine analysis testing for drugs in order to participate in any extracurricular activities in that school district. Students that participated were required to be tested before they participated, anytime during participating, or if there was any suspicious drug use. The results of the drug test were kept completely confidential, and there were no sanctions if the drug testing came back positive. So it was just information for the school to have to check in on whether or not kids were abusing drugs. And the 4th Amendment is in regards to the right of privacy and protects people from unreasonable search and seizure. So that's why they thought it violated it, because they didn't have a warrant check to see if they were using drugs. It's designed to prevent the government's intrusion in a person's private life. However, the amendment does not apply in non-criminal situations when it may be impractical for the government to meet these requirements. So the verdict in the district court, in a majority decision, the court ruled that the students doing extracurricular activities had a diminished expectation of privacy. So they decided it was important for the school to do drug tests to prevent drug use. Another case was the case of Verona School District versus Acton, where the athletes at the public school in Verona, Oregon were required to do drug testing before being allowed to participate in sports. And they ruled that it was not in violation of the 4th Amendment. Another less related case is the Chandler versus Miller case, where drug testing was required in state offices, and they decided that the state's interest outweighed the 4th Amendment. So the court did a 3-step analysis where they examined the nature of the intrusion of privacy, they examined the nature of power the faculty had over the students, and examined the character of the intrusion. The reversing of the Court of Appeals decided that the drug testing did violate the 4th Amendment, which is the right to privacy. The court concluded that before imposing a suspicionless drug test program, a school must demonstrate some identifiable drug abuse problem among a specific number of those tested. So that didn't happen, they couldn't prove that. The real question was, is the student activities drug testing policy, which requires all students who participate in competitive extracurricular activities to submit drug testing, consistent with the 4th Amendment? In a 5-4 opinion, the court held that because the policy reasonably serves the school district's important interest in detecting and preventing drug use among the students, it is constitutional. The court decided that the board's method was okay to do. This is a quote from Justice Thomas that just said that it's basically reasonable for the schools to provide drug testing so that they could prevent drug use among the students. So they did an impact study 10 years after the case, and 10 schools were surveyed on their use of drug testing. 3 out of 10 schools said they did use random drug testing, and 7 out of 10 don't. So schools have the opportunity to choose whether or not they drug test their students. The impact on the values of the schools varies depending on whether or not drug testing is required. Schools without drug testing emphasize the importance of securing legal authority to test, while the others is more concerned with parental authority and consent. The close decision allows public schools to decide whether or not they will require drug testing. They also have the decision on how far the school wants to take the extent of the drug testing.
Awesome job,
Dun, dun,
Alex.
dun, 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 dun.